think I can. Hello, Sarah. Hello, everybody. Nice to see everybody on this lovely morning. Hope the weather and vaccines are all good where you are. Um, this is what, the 21st in our series of artist workshops, and the fourth, I believe, that Sarah has been kind enough to present for us on issues related to artists and small businesses. Here at the City of Phoenix, we consider all artists to be small businesses. And so, Sarah, I just wanted to thank you for the great work that you've done in sort of enlightening folks on all these important contractual issues that are needed. Sarah Conley Odenkirk is a partner with the firm of Cowan, DeBates, Abrams, and Shepard. And she heads the entertainment group with a core practice in fine art. She's based in the firm's Beverly Hills office, where she spearheads the firm's art law practice and advises clients on matters pertaining to intellectual property, business transactions, navigating the art market, public policy, strategic planning, and I suspect a good deal more. She provides advice to artists, collectors, dealers, art institutions, and the art world negotiations and transactions that come with that. And she works with creative entrepreneurs to guide them in business development, sustainable growth, the protection of intellectual property assets. She also works with municipalities to craft ordinances, policies, procedures pertaining to public art in both public and private development. And she's also the author of a surprisingly interesting book about contracts for artists and other creatives, which contains a good deal of very, very important advice for all creatives trying to protect their businesses and make them grow. So with that, I'll be happy to turn it back over to you, Katie, for any kind of housekeeping that folks might need to know about. And I welcome everybody today. Thanks for joining us.
Thanks, Ed. Yes, just some housekeeping today. We are recording this meeting and presentation. So if you could please keep yourself on mute, that will help us maintain the audio quality for our recording so that we can post this later, where it will live indefinitely on our YouTube page. We have an archive of all of these workshops that we've been doing that exists on YouTube, and I will pop that link to our YouTube page into the chat box as well. At the end, we will stop for questions. You have two ways of submitting questions. Please feel free to type them in the chat box as you think of them during the presentation. We'll monitor that chat box and we'll go through them all at the end. Or if at the end we have additional time, you'll be able to unmute yourself and we can have more of a open question conversation. With that, I'm going to turn it over to Sarah to begin the presentation and take it away.
Great, thank you. Thanks, Katie. Thank you, Ed. It is a pleasure to be here. I'm going to attempt to share my screen. Hopefully that will go without a hitch. How's that? Can you see everything there, Katie? Awesome. Okay, great. So in our previous sessions, one of our previous sessions, we focused on copyright basics and didn't really have any time to explore the more nuanced areas of copyright law. So this is copyright law 2. And one area that is always exciting to explore is that of fair use. So that's what we're going to do today. And certainly this is an even more important area to understand as we now move through this NFT frenzy where people are minting whatever they can, whether or not they have clear rights. So hopefully this fair use conversation will be useful to many, if not all of you, on a number of different levels. I will be focusing for the most part on visual arts issues, but there are other areas where fair use, of course, applies, and I'll touch on that a little bit at the end. I'm hoping to get through my slides with plenty of time for questions. So as you come up with your questions, please do submit those. Okay. Let's see, how do I switch slides there? Okay, great. So it's important to understand that fair use is essentially a defensive position. And this is a point of controversy sometimes that's argued amongst lawyers and legal scholars. But I do think it's important to understand for practical purposes that fair use essentially comes up as a defense. When clients come to me to ask whether their artwork is fair use, I can usually give them my opinion, usually, but always with two caveats. One is that my opinion doesn't mean that they still can't get sued, because you can't keep people from filing lawsuits whether or not there's a basis for them. And it also doesn't mean that a court couldn't find differently. So even if I think that something has fair use potential, doesn't necessarily mean that ultimately that's how a court would decide. And that's really important. This is in a lot of ways kind of a murky area that allows for a lot of gray space that can go one way or the other. So my opinion, like any other lawyer's opinion, is going to be just that, an opinion. And really, it's an opinion as to whether I feel like I can make a strong case for fair use if the client were to be accused of copyright infringement. So in any case, when I'm asked, I usually give some kind of faster explanation of what we're going to go through today, and start by explaining that fair use is a defense to raise when you're challenged with any allegations of copyright infringement. And then I go on to review the 4 factors that courts consider when determining whether the use of someone else's copyrighted material is in fact fair use or not. So the 4 factors. There are 4 factors that case law and the copyright law set out as being the factors to consider, and these include: number 1, the purpose and character of the use, including whether such use is of a commercial nature or a nonprofit educational purpose. This is something that people often say, well, but it's, it's for educational purposes. That's one of the factors that can be considered, and it may weigh in your favor, but that doesn't instantly create a situation that is protected by fair use. Number 2 is the nature of the copyrighted work, and we'll get into slightly more explanation on these 4 factors in a moment, but what kind of work is being copied or appropriated, and the court will take a look at that in weighing these factors. 3 is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And the 4th is the effect of the use upon the potential market for or value of the copyright work. And we'll take a look at that. There was a recent case just a couple of weeks ago that that looked to this factor as at least part of the reasons for making the decisions. So as I said, these factors are not the exclusive means by which a court can make its determination, but these provide the skeleton on which the court can elaborate. The distinction between what is fair use and what is infringement in a particular case will not always be clear or easily defined. There is no specific number of words or amount of creative expression that may be safely taken without permission. I hear this a lot from people, but I just took 10%, or if I change this many elements, is that fair use? There's really no formula to apply. Nor does acknowledging the source of the copyrighted material substitute for obtaining permission. So you can't just say, well, I cited it, so that clears me. It does not. The important thing is to remember that the court has latitude to properly evaluate situations on a case-by-case basis. So every single situation is a little bit different and has its own specific facts. Okay, so we're going to start with a little bit more explanation for each of the 4 factors. First is transformative. So this factor, the transformative factor, purpose and character, is really important to understand because this is the primary factor on which courts have relied for a long time. And so for years, there was this upswing where the court was getting more and more expansive in their allowance of fair use based on arguments and showings of transformative use. And we'll get into that right now. But I will say that in the last few weeks, we've seen the pendulum swing. Maybe it's a little bit more than the last few weeks. Last few months, we've seen the pendulum swing a little bit in the other direction, where the courts are getting a little bit more restrictive on what they're viewing as transformative use. I'm not sure I agree with this pendulum swing, although I think what it does indicate is that there's some need to be looking at the way in which copyright and art intersects in general, but that's obviously a much bigger conversation. So in case law, the Supreme Court has emphasized that the purpose and character of the use of copyrighted material is a primary indicator of fair use or lack thereof. The question boils down to whether the use of copyrighted material is transformed to such an extent as to result in a new work worthy of separate protection. And that's really important. So in order to determine that answer, a couple of other questions usually have to be considered. Has new content or expression been added to the original work? Has this new content added to or changed the meaning of the original work? Does the new content represent additional value added, resulting in something that contains new information, a deeper or new understanding, or new aesthetic perspective? So you really have to dig into what's been added and what it does to the resulting work. Determining whether a use is indeed transformative can be difficult, as you can imagine, and the ultimate decision of the court likely has much to do with the judge's perspective on these issues. And this is potentially an issue, and there's been a lot of criticism of the courts for applying their own aesthetic judgments or their own interest in celebrity factors to adding to the reasoning of their opinions. All right, the next factor is the nature of copyrighted work. So because of the dissemination of facts or information, because the dissemination of facts and information benefits the public, there's a lot more leeway to copy from factual works such as biographies than from fictional works such as say plays or novels. In addition, you'll have a stronger case of fair use if you copy the material from a published work rather than an unpublished work, meaning that unpublished works are going to retain a little bit more protection since they have not yet been presented to the public. The scope of fair use is narrower for these unpublished works because one of the rights that the authors have or artists have is essentially the right to control the first public appearance of that work or of that expression. The stronger protection for unpublished works played a role in one interesting case involving the autobiography of Gerald Ford that we'll talk about in a moment when we talk about the third factor. The third factor is the amount and substantiality of use. And while there's no set percentage, as I said just a few minutes ago, there's no set percentage or formula to guide you in determining how much of a work it is okay to take, it is certainly true that the less you take, the more likely it is that you can argue fair use for that portion of the work that you've taken. However, you really do need to be aware of the importance of what you're taking. So sometimes even taking a small amount, if it's considered to take the heart and soul of a work, will not be considered fair use and in fact be considered a pretty egregious infringement. The seminal case on this is a 1985 Supreme Court decision that found that there was no fair use when the magazine The Nation published without permission only 300 to 400 words out of a 500-page book that Gerald Ford wrote. Ford wrote a memoir including an account of his decision to pardon Richard Nixon, which was arguably the most interesting topic in the book and perhaps the only reason that people might buy the book. Because it was specifically this part of the book that The Nation published, Ford lost a contract with Time magazine to publish excerpts of his book in Time. And ultimately, the court found that the portion that The Nation had published was substantial and in fact was the heart and soul of the work. And despite being a relatively small number of actual words, it constituted a large taking and therefore they were liable. So this is a case that really illustrates that particular principle. The fourth one is market effect. And again, this is something else that we hear people bring up a lot, but this is really an important one as well. Not whether necessarily you've made money on your the work that potentially infringes, but the effect that the use has upon the potential market for the pre-existing work. So in other words, does the use of the pre-existing work deprive the underlying copyright owner of income or sales or have a negative impact on the potential market for the original work? And we'll talk about this a little bit further when we get to one of the recent cases that did touch on this. Another factor to consider, not one of the 4 factors for balancing, but a term that's important to understand when looking at fair use in general is the word the phrase de minimis. This applies when the amount of material copied is so small, or de minimis, as to be almost undetectable. The courts may permit such use without even conducting a fair use analysis. So they might just say, it's de minimis, we're not even going to bother going through those 4 factors. Really, this can mean 2 different possible things. First, de minimis in the copyright context can mean what it means in most legal contexts, a technical violation of a right so trivial that the law will not impose legal consequences. The other meaning that it may have is that it can mean that copying has occurred to such a trivial extent as to fall below the quantitative threshold of substantial similarity, which, if you were in our last conversation about copyrights, you will remember that that is the standard that the court applies when determining whether there is a copyright infringement. Okay, so we're going to talk a little bit about appropriation art, because this is really where we see fair use becoming such an important element of how to analyze whether there's copyright infringement or not. Appropriation art, as you may all know, uses pre-existing work, often recontextualizing it with little or no change to the actual image. So, you know, we're blowing by the idea of amount and substantiality, because usually it's a very large portion. And this actually presents sort of a complication in the analysis. I'm going to try to keep these complex considerations as simple as possible for the sake of getting through this material today in a reasonable time frame so that we have time for questions. But if you find some of these concepts confusing, don't worry. You're not alone. Art historians, philosophers, artists, and lawyers, to name just a few, often wrestle with these considerations. And it is, in fact, that wrestling that I think motivates the artists in the creation of much of our contemporary artwork. The reason these considerations are interesting from a legal perspective is that we have to continually re-examine the limits of the law in providing protection for creative works. And as you know from our discussion in copyrights last time, ideas and concepts are not protectable under copyright, only tangible expressions. So this becomes a bit of a conflict from a legal standpoint if the artistic practice itself is essentially grounded in concepts and theories, de-emphasizing the tangible product. Certainly the law doesn't recognize the nuanced concept behind appropriation art, which by its nature embodies copying pre-existing images and relies a lot on the ability of the audience to recontextualize its perception of the image in order to establish that the new work is transformative. So this is really where we see at the nexus of the law and art a big difference in the way that lawyers and courts are thinking versus the way that artists put their practices together. So appropriation art, again, this is probably covering some ground that most, if not all of you already know, but appropriation art is inextricably entwined with conceptual art. However, engaging in appropriation art, the artist takes those pre-existing images as the foundation for a new work and gives them, uses them really to convey concepts based on the audience's understanding or perception of the original. Generally, there's little to no change, as I said, but it often will recontextualize or resituate the work in order to convey a concept. In appropriation work, the execution of the aesthetic element is crucial, but it certainly draws from the pure origins of conceptual art. So taking a pre-existing image, placing the image in a new context, and displaying it as a new work. Those are sort of the bases for appropriation art. So I'm just going to jump for a moment into a little bit of art history so that you have that solid foundation for how we've gotten to where we are. And I will be very quick here because I am not an art historian. While artists have always borrowed and copied from one another, appropriation art as a means for critical and philosophical comment really began at the beginning of the 20th century, which is, it's still so strange to say the last century. My kids now say, whenever I say almost anything, oh, Mom, that's so 20th century. So now conceptual art is so 20th century. Artists like George Braque and Pablo Picasso used collage in a way to bring objects like newspapers into their work. And so we see these first uses as appropriation. I mean, obviously appropriation has happened throughout history, but this is really where we start to see it become part of the artistic practice. The use of these everyday objects was relatively simple in that they were used to represent the objects themselves rather than anything more conceptual. And the rejection of the traditional narratives in favor of examining the everyday objects was a crucial turning point in art history. The use of these objects did not raise concerns of copyright infringement, but you can see that the amount of the appropriated material is rather small and more suggestive than anything else. Just a few years later, I'm sure you'll all recognize this, we have Duchamp taking it a step or two further and creating controversy with his use of the regular everyday objects selected and designated as art or ready-mades. As Duchamp said, and I think this holds just as true today as it did then, art is not about itself, but the attention we bring to it. So this sort of concept has a great deal of appeal for many people and was picked up by Dada artists and later by the Surrealists. There's no question that the ready-made revolution provided the basis for all contemporary art that followed and was the inspiring force behind pop art in the mid-century. So we'll jump all the way to pop art. Pop art in the middle of the 20th century drew from the imagery of post-war popular culture and the commercial world and further challenged notions of high art and low art. Andy Warhol's work, again, we'll see in very current case law how Andy Warhol continues to have an impact on questions around fair use. As again, many of you I'm sure know, his silk screens were based on photographs of celebrities such as Marilyn Monroe and many others. And Warhol and other pop artists at the time pushed the conversation further with the appropriation of commercial images. By using commercial expression, the pop artists added perhaps a more cynical layer on top of the idea of looking at everyday objects as raw materials for artistic expression. But this really lays the groundwork for a slightly more directed and perhaps less philosophical commentary through the appropriation of recognized imagery. Warhol was intrigued by the notion of draining an image of meaning through its mechanically precise reproduction in multiples. And in order to execute this concept, the reproductions had to be exact and look just like the original. So we see this concept within the context of creating art of having to truly take everything about that commercial image in order to accomplish the artistic purpose, even though obviously there's quite a bit of taking in terms of the intellectual property of that underlying object. Okay. Obviously, these uses were not without risk, and we'll continue to talk about that. In terms of coming up with the term appropriation art, we start to see that coming into common use in the 1980s in relation to the work of a number of American artists such as Richard Prince, Sherry Levine, and Barbara Kruger. We'll take a look at some of their works and how this fits in. These artists created photographic works of existing photographs which challenged the very notion of artistic originality and authenticity. For example, this slide shows not a great image, but an image from Prince's series of photographs of cowboys from the Marlboro cigarette ads. Prince just rephotographed the work, changing not one pixel, and then showed the work in galleries as his own. So he's changing the context and the way in which the work is presented, but nothing at all about how it appears. In this particular instance, this work sold at auction in 1995 for over $1 million. I think it was $1.3 million. And Richard Prince has established himself as a prominent figure in appropriation art, and along with a few of his contemporaries, really embodies appropriation in its purest form. That said, Richard Prince likes to make trouble, and we'll talk about one of the more important cases in a minute. Sherry Levine is another appropriation artist who's incredibly important in this analysis here. And this is one of Sherry Levine's best known works, her After Walker Evans series. As you can see, it consists of reproductions of well-known Depression era photographs by Walker Evans. Maybe some of you are familiar with the entire series. And these were taken from one of her exhibition catalogs. She created similar works for Edward Weston photos as well. And in both cases, the photographer's estates objected to her use. Levine is not, I think, able to discuss information regarding the situations, but it's been rumored that the After Walker Evans series project was actually purchased by the Walker Evans estate in order to keep it from being distributed. In fact, when the work appeared in a retrospective of Levine's work at the Whitney a few years ago, the copyright was listed as belonging to the Walker Evans estate. So you can see that when you appropriate at this level, you're almost guaranteed to have a problem. And of course, it depends on who you're appropriating and whether that artist or that artist's estate is going to go to court in order to protect those rights. The complications that Sherry Levine experienced in advancing these bodies of work resulted in severe restrictions on her ability to sell or even show the works. And so her practice has since changed to avoid running into similar problems. And her rephotographing now focuses on public domain works. Here's an example of one of her more current works. And of course, she hasn't given up on referencing other people's works. As we can see with this piece, she's referring back to Duchamp's original concept, but adding another layer addressing political and artistic issues that we do not have time to get into today. Okay. Artist Barbara Kruger is another example of an influential appropriation artist. She uses pre-existing photographs to which she adds words and in her now recognizable style of a red background with white lettering. This image, It's a Small World, but Not If You Have to Clean It, actually drew a lawsuit in the early 90s from a German photographer who claimed she had infringed on his photo. The court found no infringement because Kruger was able to rely on a change in the copyright law, which placed the photo in public domain for that moment that she used it. But the court did say that if the photo had not been in the public domain, it would have found Kruger's work to be infringing. I used to think I would be surprised if a court today found the same way, but after the last few weeks and months of court verdicts and again, this latest Warhol Foundation lawsuit, I'm not so sure. So again, these things tend to change and move with different courts and different opinions. So it's important to be aware of those trends in the courts when analyzing how risky it is to make a particular work that involves appropriation. Christian Marclay is one of the most interesting artists, I think, currently pushing the boundaries of appropriation work. And several years ago, he created The Clock, where he excerpted thousands of images from the last 100 years of film to create a montage of clips that chronicle the hours and minutes of the 24-hour period. Marclay's work is interesting and exciting in its own right, but it's really an excellent example of collage and transformative use in a way that the courts have really not questioned. Okay, so let's take a quick look at some case law, and hopefully we will quickly get to the place where we can stop for questions. Okay, so with this art history background in mind, let's take a look at some of the most important fair use cases. And really, there are a pile of them, but we're only going to go through just a couple. An important factor to keep in mind when we look at these cases is that the cases tend to note or at least take some look at the intentions that are stated behind the work. So the courts find it important to dig in a little bit beyond just the surface of the artwork and look at the intentions of the artist. Like in a pure conceptual context, the intention behind appropriation work is central to being able to determine whether a work that makes use of another's copyrighted work is transformative. This issue of intention comes up frequently. So how the intention is conveyed and how articulate an artist must be is another issue. This is something that can become very controversial and frequently has to be determined by the court or by the court process. based on the artist's ability to articulate their intention in taking work and incorporating it into their work. The ability of the artist to articulate that is going to be what the court looks to. And so in some cases, for better or worse, even though artists aren't necessarily trained to be articulate about their specific intentions always, and sometimes there's a purposeful lack of articulation about intentions that's part of the work, that comes into clash with the way that the court looks at it. Okay. So this is Richard Prince yet again. And this was a case a few years ago that really caused quite a lot of waves in the art and law community. And I'm sure many of you have seen articles about this. So let's take a look for a second at this case, Cariou versus Prince. We saw earlier that Prince was a pioneer in contemporary appropriation with the Marlboro Man photos, among others. And in this recent case, Prince was sued by fashion photographer Patrick Cariou. Cariou published a book with photos that he had taken during the 1990s when he lived and worked with Rastafarians in Jamaica. Prince took several images from this book and used them in 30 paintings. You can see one of the examples here, Cariou's original image on the left and Prince's work on the right. As a result, Cariou sued Prince and Gagosian Gallery, who'd shown and sold several of the paintings for well over $10 million. And the case went to court and was appealed. So the district court found that Prince's work was an infringement and did not qualify for fair use. That was a little bit of a surprising decision, but what was even more surprising was the court's remedy. The court ordered that all the infringing work be destroyed. So you can imagine how the collectors who'd paid millions of dollars would have felt about this remedy. But following that, there was an appeal, and in the appeal, Prince won with regard to 25 of the 30 works. The appellate court found that the 25 works were in fact transformative and presented a fundamentally different aesthetic. For those who champion appropriation art, the appellate outcome, of course, was far preferable to that of the district court. However, critics raised a number of concerns, one of which being that they were uncomfortable with the court being involved in the business of assessing the aesthetic merits of artwork. So this is sure to be, of course, an ongoing debate. The remaining 5 paintings, as I said, 25 of the 30 were found to be fair use. The remaining 5 were sent back to the lower court, but ended up settling in the meantime. Before the ink was even dry on the settlement agreements, Gagosian had already planned another show of the Canal Zone works. And as any good appropriation artist representative does, Gagosian took it a step further by creating derivative works in the form of merchandise like posters and t-shirts. Last time I checked, they were sold out, but there may be more on the website at this point. So from a collector's standpoint, the outcome is certainly a relief because they get to keep their Richard Prince works. Not only do collectors who bought the work initially not have to destroy their pieces, but with all the publicity around the controversy, it's likely that the value of the works has increased on a fast track, which of course begs the question as to whether legal controversies, albeit risky, are actually the new best marketing technique for appropriation artists. And we see this happening over and over again. So this is another, and it was funny as I was putting this together, the 3 cases, not because they all involve someone named Prince, but they happen to, there are 3 cases here that all involve, or maybe 4, that all involve Prince, either Richard Prince or this Prince. So this legal battle just resolved a couple of weeks ago, stretched back to April of 2017, when the Warhol Foundation preemptively sued photographer Lynn Goldsmith, arguing that because she was claiming that the Warhol's use of a photo that she had taken was infringing. The Warhol Foundation went to court preemptively to have the court determine that it was transformative. So as I said, this was a case around a photo that Lynn Goldsmith originally took in December of 1981. The photo was licensed by Vanity Fair, And then Vanity Fair commissioned Warhol to create an illustration for an article about the musician Prince. Warhol then went on to create 16 works based on that photo. But Goldsmith claimed that she wasn't aware of the Warhol works. So initially the lawsuit was decided in favor of Warhol on the grounds that Warhol sufficiently transformed the photograph in his work by fundamentally altering her image of a vulnerable, uncomfortable person into an iconic, larger-than-life figure. However, just a couple of weeks ago, the appellate court decided that the Warhol renditions of the image could not be considered transformative despite the completely altered aesthetics. The court held, quote, while the cumulative effect of those alterations may change the Goldsmith photograph in ways that give a different impression of its subject, the Goldsmith photograph remains the recognizable foundation upon which the Prince series is built, close quote. The court further determined that the Warhol work damaged the market for Goldsmith's work. I actually disagree with a lot about this decision. But the bigger question here really is whether it's a harbinger of that pendulum swing back in the other direction, away from the courts being so supportive of transformative use. So that's something for us to all keep an eye on. Okay, so before we wrap up and take questions, I'm just going to touch on a couple other things that are not fine art related, but certainly are appropriately connected and may be of use here as well. This slide refers to a case from a few years ago, the Google Books case, which was decided in 2013. Years ago, Google decided to pursue the enormous task of scanning text in order to create a comprehensive word index that helps scholars, researchers, and readers locate books. They quickly realized that obtaining permissions to do this from all the potential copyright holders would be prohibitive both in cost and in time. So Google decided to take a huge risk and just plow forward with the project. A number of authors and publishers banded together to sue Google for infringement. And after almost a decade of controversy, the court finally ruled on the Google Books project, finding that Google's actions qualified as transformative and therefore fair use. This was really interesting because it was actually an opinion written by a judge who wrote an article years ago on which this whole transformative use theory became such a popular, I don't want to say crutch, but a popular go-to for the courts. So it was sort of a full circle kind of case. Since the Supreme Court declined to hear the appeal, the ruling stands that the Google Books project is fair use. Okay, so when it comes to fair use regarding online material, again, another area that's going to continue, of course, to be a really important area for people to pay attention to. We have to consider also the Digital Millennium Copyright Act. The DMCA created the so-called notice and takedown system, which gives service providers immunity from copyright liability for content posted by users if the providers take it down when they're notified that there's an infringement. However, sometimes lawful material is targeted as well, and this is potentially problematic, right? You don't want the large companies to be able to keep people from actually using work in a fair use context. So to discourage such abuse, Congress made sure that the DMCA included a series of checks and balances, which gives users the ability to hold copyright owners accountable if they send a DMCA notice in bad faith. This was tested in the Dancing Baby case, or our third Prince case for the day. Stephanie Lenz, this is in 2007, Stephanie Lenz posted a YouTube video. It was a 29-second recording of her son dancing to the Prince song, Let's Go Crazy. The case raised the question of whether a copyright holder can use the DMCA to take down an obvious fair use without any consequences. So after she posted her video, Universal Music Group sent a takedown notice to YouTube claiming that she didn't have permission to use the song. So YouTube removed the Dancing Baby from the internet. Lenz, with the Electronic Frontier Foundation, successfully petitioned YouTube to restore the video and then sued Universal, claiming that they had failed to properly review her video before submitting the takedown notice. The court held that the DMCA requires copyright owners to consider whether the works are in fact potentially a lawful fair use before sending the takedown notice targeting them. This is important because it requires rights holders to consider whether fair use could allow the appropriation before they can move to have the content removed from an online platform. And again, we're going to continue to see some evolution in this area as more work is posted online. All right, so we've taken a look at a few cases and images and covered a lot of artistic ground as well. Fair use is a very complex area and definitely full of many potential pitfalls and landmines and muddy water. But hopefully now you have a better idea of what the landscape looks like. And the bottom line is that there are no bright line tests. Much of the decisions are based on, much of the decisions as to whether something is fair use don't rest, it's not something that's simply resolved. It's something that the courts go back and forth on. So nevertheless, it is a unique area of the law. And it is very difficult to divorce aesthetic views from legal opinions, although certainly the courts struggle with that balance. And I do think that a lot of these cases point in the direction of it maybe being a good time for us to take a look at the way that copyright and law work together, and think about whether we could accomplish something better with a systemic overhaul. Okay, so with that, without going further into any paradigmatic shifts that I think may or may not take place, let's open it up for questions and see what we can have a conversation about. I think what I will do is stop sharing so I can actually see what's going on here.
We have a lot of questions in the chat box
Great.
that have come in. And I'm gonna have to ask for some clarification on some of them, Case, because I'm not sure I fully understand, but I'm gonna just start at the top and work my way down. And I don't know. Case, are you able to unmute yourself by any chance?
Yep, I'm here.
Okay, super. So your first question is about 3D printing, wood, metal, organic. What sort of questions do you have about copywriting in regards to 3D printing?
Yeah, if you were to scan any object out there in the environment, say like a piece of artwork or whatever, and were to print it, does copyright apply to that if you're creating something brand new in a different metal or substrate? So if an artist makes something bronze.
Right. So changing the medium does not get you out of being infringing. So it's not a question of whether you've changed the medium or even changed aspects of the way it's presented. The standard that the courts apply is substantial similarity. So if I look at the original work and I look at your 3D rendition of it, do I think it's substantially similar? That's going to be the question. Does a jury think that? Does the court think that? So that's the standard. And again, it's kind of it's a gray area. It's a mushy standard. So there's not necessarily a clear answer for every single situation, but substantial similarity is the term that you need to keep in mind when you're doing that.
Nice, awesome.
Okay.
And then you also had a question about copyrights and when they would expire related to republishing content from old magazines or articles.
So copyright is, you have to assume that copyright's going to apply unless it has fallen into the public domain. And it gets a little bit complicated before 1978 because there were different rules that applied. But for the most part, every year, right around January 1, we have an article that will come out in the newspaper that talks about all the wonderful things that are going to fall into the public domain this year. And that usually is looking back to a date in the 1920s at this point. So anything before the mid-20s, you're likely to have in the public domain for US works. And then between the 20s and the late 70s, there are some questions that can impact whether something's in the public domain. But copyright lasts for the life of the author plus 70 years at this point. So again, you have to analyze each thing that you might want to be borrowing from in order to determine whether it's in the public domain or not. But generally speaking, magazines in the last 50 years are not going to be in the public domain.
Now, say if something's copyrighted and the author's dead, 70 years have expired, can a foundation that basically operates or runs something for that author or artist, can they reapply for a copyright or patent or something?
That's interesting. So I can't be giving specific legal advice. So generally speaking, if there's something that has expired and gone into the public domain, no, you can't reapply for copyright protection. But that said, certainly in the museum world, there is and has been a tendency to try to still control the access to images by being the source of those images. So even if copyright has expired, if you happen to be the one that holds those best images, the either high resolution images or the artwork itself, and you're able to control who has access to that, then you can still have some economic control over access to those images, but you're not going to be able to create a new copyright with the original work. You can create a new copyright if, say, you did a compilation work. Let's say it was a bunch of poetry that's fallen into the public domain, but you decide to curate a sampling of public domain poetry, and you put a forward and afterword and some descriptions in between. What you put together is a compilation work of other people's work, and you certainly have a copyright in that compiled book. So in some ways there are some end runs, but for the most part, once things are in the public domain, that's where they are.
Awesome. And kind of to touch on that, say like words, if it's, past the 70 years and past the life of the author, can the words, whatever they're using, still be copyrighted? As far as like, if you were to buy a domain with that copyrighted word, would they have any liability against you or whatnot?
I'm not sure I understand the question. I mean, you can't
say for instance, like
words.
Yeah, just like a word. So like if it's like a word the artist used that's attributed to that artist and it's past the life of the author plus 7 years, if you were to go out and register a domain, did they have any right to be able to give you like a cease and desist to basically give up that domain?
Okay, so I'm going to say it depends. But if it's something, so short words and phrases and titles and individual words are not protectable. If there's a word or a phrase that's associated with a person, that's a slightly different right that we're talking about. It's probably not copyright. It could be trademark if it rose to the level of being used as a trademark. It could be something that that has to do with rights of publicity. But generally speaking, people are not going to be able to protect an individual word or short phrase. The issue would probably be more along the lines of, are you trying to trick people into thinking that you are that artist, or that you are selling something that is authentically that artist? So if there's some legitimate allegation of fraud or deception that goes along with any claims, that would be, a more problematic analysis.
Gotcha. Thanks.
Case has a bunch of other really interesting questions that he's typed in here. We're kind of running low on time, so I'm just going to pick a couple. Is there a law against taking someone's DNA that they left behind and using it to create something, a new living organism, art, etc., or is our DNA automatically copyrighted and patented?
Wow, that gets into a really interesting art and science area. DNA is not automatically copyrighted. I think that this is bringing in a whole lot of other medical ethics and art ethics questions that are fascinating. And hopefully, if you are paying attention to the next iteration of Pacific Standard Time that the Getty funds, the topic is art and science. And so I imagine that there are going to be a number of projects that are looking at those exact kinds of issues. And certainly there are a whole host of projects that have been criticized or critiqued or examined that are exploring these kinds of issues. So again, less copyright and more a question of ethics and moral issues. So I'm not sure that I have a copyright answer for you there.
I'm gonna pop a
Thanks.
link to that Getty Foundation Pacific Standard Time in the chat box if anyone's interested in looking into that more further.
I do think that we're going to see a lot more artwork that looks at those kinds of issues. And, there's this weird thing happening with an exploration of what it means to be human, what it means to be part of our society now with all the tech stuff that's happening, and what's that relationship between tech and science and human versus machine. And those are some really, really interesting and fertile areas to be considering.
Another question I think that's really interesting is, does copyright law cover users outside of the US? Like, does it cover makers who are outside of the US, or does it cover people who are potentially violating
Yeah.
makers in the US?
So one of the reasons that we in the United States passed the Visual Artists' Rights Act in 1990 is that we wanted to be part of the Berne Convention, which is an international convention that protects copyrights in all the signatory countries. So if you're a signatory of the Berne Convention, which we now are, your rights are recognized in other signatory countries, and those signatory countries their rights are recognized here. So there is some reciprocity. There is no international copyright, so there's not one place to go apply to for international protection. So it's important to know whether the country that you're dealing with or operating in or in being infringed in, whether it's a signatory country, and how that allows you to either bring a lawsuit in that country or here based on that country's rules. So yes, there is some international protection, but it's not based on an international law. It's based on a treaty that many countries have signed. I also see that there's a question here about copyright law in outer space, which is a super fascinating area as well, because of course, when you're out in space, who owns space? And generally speaking, till now, the decisions have been based on whose property those rights have been developed. So if you're on a US spacecraft and you create something, that's probably going to be controlled by US law. Now, of course, it raises some issues if you're on the International Space Station. And I think that we're going to, we'll definitely see more litigation and consideration of how those kinds of inventions and creative expressions are protected. So there's definitely a developing area of space law.
Kind of touching on that there. If you're in, say, like in some waters that are, I think there's some designations where there's no country,
National
like
waters,
what applies there as far as, what's that?
If you're in international waters?
Correct.
Well, I mean, generally speaking, if you're on a vessel in international waters, you're flying a flag of some country. And so there's going to be, maritime law will determine what law applies, but it is probably the flag of whatever country you're flying. There are some communities that have been established out in international waters as being separate from any countries. And so that certainly does raise some interesting questions about what, if any, protections artistic expression has in those communities, but I'm not sure I'm qualified to answer that without doing some research. But interesting questions for sure.
It sounds like if you wanted to do something that was unethical or really bad, that'd be the place to do it.
I would never advise anyone to do anything unethical or bad, period.
Just places
Okay.
that we probably should be watching out for.
We have about 3 minutes left. And Sarah, I know you have to leave right at 11. So I just wanted to see if there were any other questions from anyone else in the group. I think you should be able to unmute yourself if needed. And just wanted to say thank you again so much to Sarah for joining us today. We will be posting the recording of this online. Sarah, would people be able to follow up with questions to you?
Absolutely, yes. My email, did you put my email in there?
I did not. I
Okay.
want to make sure that was okay with you first.
Yes, that's fine. People can feel free to follow up with me via email. It's sodenkirk@cdas.com. And yeah, I'm happy to be available as a resource. Obviously, I can't give hours of free legal advice, but I'm always happy to answer a quick question or point you in the right direction if I can be of assistance.
All right. Anything else from the Office of Arts and Culture?
Just a big thank you to you, Katie, for coordinating all of this, and Barry and Doug, and then also Sarah, thanks so much for joining us for this
Sure,
and
it's been
sharing
my
your expertise. And one and all, thank you for joining us today. And I guess stay tuned to our website for further workshops that are coming along in the weeks ahead. And if you have ideas for others, we may take a pause this summer, but I think we'll be doing a series of online workshops into the future beyond that. So stay tuned.
Thank you, everyone.
Thank you.